So I want to welcome everybody here to our webinar. And I think a lot of you know this from maybe seeing a video I put on YouTube. This will be a two-part little project here where we're going to go over what happens to your credit reporting after you get a discharge in bankruptcy. And this first one will be more kind of laying the foundation. What does the law say? What are the types of common errors that we see? And then next week, we'll spend most of our time actually going through examples of actual credit reports. And I would like for a lot of those credit reports to come from you guys. If you've been through a bankruptcy and you think there's something wrong with your credit report, or maybe you have clients or customers who have been through this, and assuming you have their permission, send those to me. If I use anything, I'll redact out all the personal information. And let me pull up our slide presentation here, and we will get started with this. And okay. So as I mentioned, what we're going to do is talk really about Chapter 7 bankruptcy and after you get that discharge. So the way a normal case goes, you file the bankruptcy, you have what's called a 341 hearing, which is what's called a meeting of the creditors. And then you get your discharge order. And for most debts that are listed, usually not certain tax debts and not student loans, your other debt is wiped out. It is discharged. But what's your credit report supposed to look like? And does it always look correct, or are there errors with it? And that's what we'll go through in our presentation today. And next week will be definitely more interactive because I'll put stuff on the screen, credit reports, and say, okay, let's figure out, kind of like we did if you were part of the a couple of classes where we just went through charged off debt and did that. This one, I want it to be interactive. I want your comments. And what I'll do is kind of each section, I'll stop, take a look at the comments, and I might need to sort of move some of the questions down a little bit later, but I will try to answer every question that's asked. And so let's just start with a couple of stories. And these are, kind of the types of cases that we have handled over the years. And so one is very simple. We have a medical bill, and then we file bankruptcy. That medical bill is discharged, and now some collector is on my credit report reporting that as owed. Well, that's a violation of the law. Same thing if it's a credit card, same principle. So I have a debt, I filed bankruptcy, it's discharged, and then it's showing up on my credit report with a balance owed. That's a problem, and we'll talk about that. What if it's a mortgage debt? Again, that's discharged. So I have the debt, I filed bankruptcy, it's discharged, and now they're reporting a balance, and they're reporting after the discharge for the months after the discharge. I'm 30 days late or charged off or 90 days late or whatever it is. That's a problem. What about if they show a zero balance, but those months after the discharge? I'm not talking about stuff in the past. I'm talking about after the discharge, they show, for example, a charge-off every month. It's a problem. Or what if, let's say it's Capital One, and I only have one Capital One card, and I discharge that. I have no other Capital One cards. I don't apply to Capital One. And then I find after the discharge, Capital One has done an account review, a soft credit pull. Does that violate the law? Well, the answer to all of these is yes. So these resulted in lawsuits. These result in the credit report being fixed, usually the matter in question being deleted, and then money damages. So this is what I want to talk to you about today. And so real briefly, this is for lawyers. So I'm a consumer lawyer. This is for consumers, because you may be sitting here and maybe you've gone through a bankruptcy, or maybe you're in the middle of a bankruptcy, or you're thinking about it, or you may have family or friends, or you may be a credit repair company and you've got customers who either are going through this or have gone through this in the past, and you want to see, okay, what can you learn from this? And so whatever your position is, whatever your status is, I'm glad that you guys are on here and I want to make this as valuable as I possibly can. So I'm not going to spend much time on this. Just to let you know, I've been suing these companies since about '07. And there was probably a 2-year period where, I mean, there were some months we were filing 25, 30 lawsuits a month. And we saw tons of violations, and then that would sort of peak and then go down, and then you don't see them anymore. And then they come back, and then they go down. It feels like that they are back now pretty strong, that we are seeing a lot of violations. And, I have, current cases right now on this exact subject. So there are definitely companies that are breaking the law with this. And the reason I think it's never permanently fixed, I mean, it's a pretty simple concept, okay? There's a debt, there's a discharge, don't show it with a balance, don't report it as late after the discharge, don't pull a credit report if you have no other accounts other than a discharged account. Pretty simple. Well, why do companies violate the law? It's all about money. Because when you go to close on a house or to do something, maybe have a security clearance, and there's this $5,000 debt, you're like, yeah, but that was discharged. I go, well, you got to get rid of it. Well, you may be tempted to call the company and pay them a couple of grand. And then they'll say that was a voluntary payment. We didn't force you to pay that. You wanted to pay us. That's the argument that they've made in court. It's not very successful, but that's the argument that they make in court. All right, so let's talk about what you'll discover in this. There's a couple of key points. One is, you probably have heard this expression with bankruptcy, this idea of a fresh start. What does that mean? Okay, and how do companies violate that? We'll talk about what it means that you have to properly notify the creditors or the collectors, how to pull the right credit reports at the right time, how to find the potential errors, and then what do you do about that? And then what if you've done all that and you dispute? Can you sue? Can you not sue? We'll talk about that some. All right, so let me check out our questions here, or our comments, before we get too much further in. Okay, so sounds like everybody is doing very good. And let's see, John asked a question. Macy's knew about bankruptcy and continued to report this for the past several years. Is that willful? It can be. And so, John, if you'll make sure when we get to that part, let's come back to that question. Okay, so I'm going to make a mental note, and hopefully I'll be able to remember my mental note, and we'll talk about what exactly is willful. Okay, and there's a couple of parts to that. It's a very good question. Okay, so here are some violations. Now, there are more violations than what I have on the screen, but these are, I'll say these are really like the big two, and then there's a bonus. Okay, so the number one, kind of the classic violation, is there's a balance, okay, other than zero or other than just blank. There is a balance, $100, $1,000, $10,000, whatever it is, that shows up, and this is after your bankruptcy. Okay, so let me clarify what I mean by that. So I have a Capital One card. I owe $5,000, and they report, this month $5,000. I filed bankruptcy, and then after that, it still shows a balance of $5,000. They don't have to go back in the past and change that I had a $5,000 balance before the bankruptcy. It's now that I've had the bankruptcy, the balance for each month after the bankruptcy, and certainly just the overall balance, better not say $5,000. It better say zero or blank. The second most common one, and usually this is combined with the first, but I have seen these separated, is let's say that you're charged off. You're charged off. You file bankruptcy. You get the bankruptcy discharge, and they just continue to report each month that you're charged off. Okay, so not the past, but after the bankruptcy, they're reporting that. Now, they may show a zero balance. They go, well, see, we showed a zero balance. Yeah, but you told the world that this month and this month and this month I was charged off, and I wasn't, because you can't be charged off if it's discharged. Okay. In the past, it could be charged off, but if there's a bankruptcy discharge, that's it. Now, courts differ. What if it says charged off and discharge are included in bankruptcy? Some courts would say that's okay, but clearly after the bankruptcy, they cannot be doing that. And they cannot just say charged off without saying that it was included in bankruptcy. The third one is, it's sort of hard to say, is it more common or not? Here's the situation. So I have a Discover card. I filed bankruptcy, and I have, let's say, 2 Discover cards, and one of those I reaffirm. So I agree again to be bound. And then after the bankruptcy, they pull my credit report. Well, one of the accounts was discharged, but the other wasn't. They're okay on that because we have a business relationship, so they can do an account review on me. But if I only had one card, or let's say I had 2 and both were discharged, and then Discover after that does a credit pull on me, that is almost certainly going to be a problem for them. Now, we're going to talk about making sure there's good notice and things like that. So, and I have this little warning here because I don't want to keep saying it. We're not talking about if you reaffirm a debt. If you reaffirm a debt, you owe that debt. Okay. So again, you file bankruptcy, you're rocking along, you're about to get your discharge. You say, you know what, I want to keep this car. And so you reaffirm it. Well, on the other side of that discharge, you still owe the debt because you agreed to it again. You reaffirm the debt. So we're not talking about that. And what we're talking about are debts that are actually discharged. So sometimes people say, well, I got my discharge order. That means my $300,000 in student loans is wiped out. Well, the discharge order says those debts which are dischargeable are discharged. Typically with certain tax debts, certain student loans, you would have to bring what's called an adversary proceeding in bankruptcy, where you get a judge that issue a specific order that says these debts are wiped out. So all we're talking about in this class is stuff that is actually discharged and was not reaffirmed. Okay, so I probably won't do any more disclaimers after that. Okay, let's see. Jeff Clayton says, does this apply to Chapter 7 only? No, not really. I'm going to only speak in terms of Chapter 7 here because 13s get a little complicated. And now the bottom line is, if you have a discharge of a debt in 13, that's the same as a discharge of debt in Chapter 7. But there's a whole nother set of issues with Chapter 13. I really wanted to save that for another one. I figure we'll do 2 on this, and then I thought maybe the following week we would do a class on when does a company have the right to pull your credit report. Do you have to give them permission? Is that the test? Or is this thing called permissible purpose? What is it? And I thought that might be interesting for us. And then maybe after that, we'll do Chapter 13. So good question. All right, very quick review. I'm assuming a lot of you guys have been on some of our other webinars or you've seen our videos. So very quick review. Under the Fair Credit Reporting Act, the FCRA, we really have 2 groups of people. We have the credit bureaus and then the furnishers. So let's talk about the credit bureaus for a moment. 2 major laws we're talking about: 1681 EB, okay, and that is reasonable procedures for maximum accuracy, and then 1681 I. And some of you probably tired of hearing me say this, but you can remember the I stands for investigation. It's when we ask the credit bureaus to investigate our disputes. Now, the other side of this is furnishers. And while they have obligations to do accurate credit reporting, for our purposes under the Fair Credit Reporting Act, we really have to do a dispute through the credit bureau, who then notifies the furnisher. Now the furnisher has liability where we can sue them if they blow this investigation. So we've got the credit bureaus. This EB is something where they have to do this just all the time. And we normally don't bring these cases, but actually bankruptcy is somewhat of an exception. So normally we only sue after we dispute, but sometimes I'll sue even without disputing the credit bureaus. If we want the 1681 I, we have to do a dispute through the credit bureau. And if we want to be able to sue the furnisher, so you've got the credit bureau up here, the furnisher is the one that provides or furnishes the information. So that's your Capital One, your Midland Funding, your LVNV, Bank of America, Citibank, Synchrony Bank. All those are data furnishers or providers to the bureau. So if we want to be able to sue those guys, we've got to, under the FCRA, we have to notify the credit bureaus first. And I almost always notify the credit bureaus, but there are some exceptions, and we may get into those. Okay. So FDCPA, Fair Debt Collection Practices Act, this only applies to debt collectors. And, it's very, very common for people to come up to me, even lawyers to come up to me and say, hey, John, I got this great FDCPA case. And I look at it, I say, is the defendant a debt collector? Well, no, but they were collecting a debt. Like, that's not the same thing. They have to be a debt collector under the law. We're not going to go over the requirements of that, but assume they are. Then this section 1692E8 is where we can get into liability for them, and we do not have to dispute. So if we want to sue under the Fair Credit Reporting Act, we have to dispute through the credit bureaus. They have to then notify the furnisher. But if it's a debt collector, a lot of times we can sue just sort of straight up. Let me show you something very quickly here. So if you look at this, and I've got this pulled up, this is section 1681 EB. So this is for the credit bureau. So in consumer reporting agency, credit bureau, those are all the same thing. Prepares a consumer report. It shall follow reasonable procedures to assure maximum possible accuracy. Now, when a credit bureau knows that you have an account opened in 2015 and you file bankruptcy in 2021 and get a discharge in 2021, and that same account that was opened back here in 2015 is reporting with a balance, they should go, wait a minute, that doesn't look right. Okay, so they have some responsibility to look at this stuff even before you make a dispute. Now, if you make a dispute, this is under section 1681I. And let me just highlight part of this. So it says that the completeness or accuracy of any item of information, that would include an inquiry, that would include the balance, that would include the pay rating or pay history. Different bureaus call it different things. So if the completeness or accuracy of any item is disputed and the consumer notifies the agency, then you get the obligation placed on the credit bureau to actually go investigate. And part of that investigation means they have to reach out to the furnisher and say, hey, the consumer disputes this. Is it right? Is it wrong? And now both the credit bureau and the furnisher have an obligation to investigate. Now, let me show you the law on the furnisher. So this is what is known as, let me back up here. Okay. So this is 1681 S2B. There's a subsection called A, and it's got great language. You just can't sue for it. But B, you can. So notice what this says. After receiving notice pursuant to 1681I, that's what we just talked about, of a dispute with regard to the completeness or accuracy of any information, then they have to do this investigation. Okay. And then the last one will be the FDCPA, and this is section E8. So just get this. So threatening or actually communicating to any person, that would include a credit bureau, credit information which is known or should be known to be false. That violates the FDCPA if we're talking about debt collectors. So if they know the debt's been discharged and they continue to report it, that's going to be a problem for them. Okay, let's go back to our presentation here, and let me check our let's see our comments here. So there's a question from John about pulling credit after statute of limitation. That really doesn't affect their ability to pull a credit report, but we will talk about that. If you'll remind me in probably about 2-3 weeks from now, we'll do a whole class on when a collector, when a furnisher, when a creditor, when anybody can pull your credit report, okay? And very strict rules about that. Let's see, Derek says, how do we verify the credit bureaus actually notified the furnisher? It's a great question, Derek. And sometimes we don't know ultimately until we sue. But one way that will give us a pretty good insight is, let's say Equifax gives you the results of investigation, and it will say, hey, we reached out to the creditor and the creditor said that this information is reporting correctly. Okay, well now Equifax may have lied, but they're at least telling us they did that. Same thing with Experian, with TransUnion. Typically, they'll say the creditor is verified to us or has updated information. And so, again, there's no way without getting the actual ACDV, which is the document that goes really between the bureau and the furnisher and then back. So the ACDV will say, hey, this consumer, here's their name, their social, here's their complaint, here are the documents they've attached. And then on that same document, that ACDV, the furnisher will sort of fill out the other side. So on this side, it's the credit bureau. This side, it's the furnisher. It goes back to the credit bureau, and then the credit bureau decides based on its own investigation and what the furnisher said, do we keep it, delete it, update it? What do we do? So good question. Let's see. Ryan says, client got a Chapter 7 discharge 2019. TransUnion shows a balance of $875, but the pay status says included in bankruptcy. So report shows a balance, but also notes it's included in bankruptcy, and all the boxes in the payment history since then have an X. Yeah, that they're kind of trying to split the difference there. And this is a big battle with TransUnion right now. And these are called pay status cases. And actually, I just saw a new decision. I saw it today. I think it came out maybe yesterday from Southern District of Florida. TransUnion says the pay status means historically, what it was years ago. Consumers take the position it means what the current status is. I certainly would dispute that and say, hey guys, you should show the balance as being zero. And if they didn't fix it, I would sue them. And I might even sue them even if they did fix it under that EB. So Ryan, if you want to reach out to me afterwards, I'd be glad to chat with you about that. Let's see. So Murley asked a question about 1681 S2A and I and EB. So I and EB only apply to the bureaus. S2A only applies to the furnishers. Okay. But remember, under S2A, and I'm not trying to get overly complicated here, but we can't sue under S2A. We can only sue under S2B, and we only get that if we notify the bureau, then they notify the furnisher. Let's see. There's a question. If bankruptcy is dismissed, how do you go about disputing it? So if you're talking about disputing the bankruptcy itself, you just have to find errors with the reporting. But a dismissed bankruptcy will have no effect really on our accounts. Okay. That's not 100% true, but it's almost always true. So we're really just talking in this webinar about what if we got that discharge, okay? Because that means they cannot collect the debt anymore. And okay, so let's go back, and then I'll come back to those questions. So I think where we left off was this slide talking about the FDCPA. So now let's talk about this fresh start. And I've sort of hinted at this bankruptcy. So keep in mind about this. When you file bankruptcy, you pay a price for that. Now, there's a dollar amount to the lawyer, whatever that is, but you pay a pretty heavy price on your credit report. Okay. And you either have filed bankruptcy or you have not. So you may be applying for a loan 5 years from now. Even if the bankruptcy is off your credit report, they still say, have you ever filed for bankruptcy? If you lie on that, that may be mortgage fraud. Don't lie. Okay. So you sort of bear this burden of having bankruptcy. And I don't know anybody who goes into bankruptcy just in sort of a flippant manner. I mean, it's a gut-wrenching decision, but we file bankruptcy because there's just no hope. We're just so buried, and we truly need a restart. And that's the whole idea of the bankruptcy. It's a fresh start. This is not a new concept. You really can find this concept in the Old Testament. Okay, so this is not something that was invented 20 years ago, or even 2,000 years ago. I mean, this is an old concept to say at some point we may need to kind of get that fresh start. Well, the fresh start means the discharged debts are wiped out. It's like there's a wall above you, to either side, below you, in front of you, behind you, and that debt cannot get through that wall to you. And if somebody tries decides to collect a debt that's been discharged, they're violating the bankruptcy court order. And so they can't do that. There's no collection on it. There's no reporting that you owe that debt. Now, they can report that you did owe it. They can report that currently the debt is discharged. But what they can't do is say, on that $5,000 Capital One account that I discharged 3 months ago, they can't say that I owe $5,000 today. That's absolutely wrong. There are a few scattered courts that have just frankly completely missed this. Thankfully, in the 11th Circuit, which is Alabama, Georgia, Florida, and some most recent law on this, great decision called Loesch, Losch versus Experian. And I think I have maybe a 40-minute video on this last year. I think I did the video like the day after the opinion came out. Just a fabulous opinion. And they really hammer home, discharge debt, you don't owe it. And they even reference a U.S. Supreme Court case called Midland that also sort of in a passing way says, discharge debt, you don't owe that. Okay. So what happens is when these companies start doing these violations, and for our purposes, we're just going to talk about the three that I've mentioned. There are others, but they get a little more obscure. These are kind of the big three, really the big two plus that inquiry one. And when these companies start doing that, they really take away your fresh start. So you paid the price for something, but you're not getting it. And I have a couple of examples, on the screen. You pay for a hotel room, then they're like, there's no hotel room. Or you go to work and you do the work and they go, we're not going to pay you. Okay. So you paid the price, you've suffered the consequences of bankruptcy. Now you get the benefit. But these companies that are willing to violate the law are keeping you from getting that benefit, and they should be held accountable for that. All right. So I've mentioned a couple times this idea of properly notifying. What do I mean by that? When we file bankruptcy, we list out in our petition, oftentimes called the schedules, we list out all of our debt. So we've got unsecured debt, we've got secured debt, and you really want to list every single person. If you're like, well, I'm not sure if this company has it or that company, put them both down. Okay. Put that down and send notice of the bankruptcy. And at least where I practice, we would notify the court, then they actually send it out. But you want to put everybody. So if you know of a collector and the original creditor, I would put both down. Okay. You want that notice to go to everybody that could possibly be involved in this. And if that happens, once they're notified, they're going to get notified of the discharge. Okay. And when that happens, they have no excuse now. I mean, they go, oh, well, we forgot or we got confused. But what you don't want is to leave off the $5,000 Capital One account. And then you find them reporting and you're like, hey, I want to sue them. Like, well, we didn't tell them about the bankruptcy. Now, in most states, I don't want to get bogged down in this, but in most states, cases are what are called no asset cases. So we're not, like we don't have 3 mansions we're selling and, paying off our debts. It's like, hey, I don't have anything. And so typically, even if you don't list somebody, as long as it wasn't done intentionally, that should be considered discharged. But all you're doing is giving the person an out. So if you have any doubt, you can go back to your bankruptcy attorney, or there's different approaches, but you want to give notice to the company so that they know, oh, okay, yeah, this debt was discharged. Okay. So let's talk about the credit reports. Who do you pull and when? And the when is very important. So, if you've heard any of my videos, I always harp on this. Pull your real credit reports, not Credit Karma. I mean, it's fine if you have that. It's fine if you have Smart Credit, Identity IQ, but you got to have your real reports to get the real data. And so annual credit report, at the time I'm recording this in March of 22, we can go every 7 days to get our real credit reports from annualcreditreport.com. You can go to myequifax.com, totally free. They don't give you necessarily a report you can print, but you can sort of look at each account. Go to Experian.com. They'll give you your actual report. TransUnion. I'm not aware, maybe somebody that's on here, I'm not aware of being able to pull the actual TransUnion report for free other than through annualcreditreport.com. Now, there may be some backdoor, through like TransUnion trying to sell you a credit score. They might give you a free report. I'm not sure. So if anybody knows about that, let me know. But definitely annualcreditreport.com. If you had to, just go buy a report from TransUnion. Innovis is another one. And here's the key. You really want, from your bankruptcy, discharge about 90 days. Okay. Technically, they don't have that long, but that's a good rule of thumb to wait 90 days. Because remember, we talked about that EB claim. So let me just make that go away for a moment. The EB claim says to the credit bureaus, you have to have reasonable procedures to assure maximum possible accuracy. Pretty strong language, right? So what that's been interpreted in, and some of these are from some class action settlements, is that when the credit bureaus, they know that an account was open back here because of the open date. And then they know, because they're reporting your bankruptcy, they're reporting your discharge. And then after that, the same account is now over here, okay? And it's reporting a balance. That should trigger all sorts of red flags, alarms, and go, wait a minute, what happened here? Let's check this out. Because they're pulling the information. And I know some people get real worked up about this. They're not actually pulling it. Usually it's LexisNexis. It doesn't matter. Okay. The bureaus, either directly or through somebody that they pay, they're pulling the information and they can dig down into it. Okay. You really want them to have that 90 days so they don't have an excuse. They go, well, it happened too quick. You just got the discharge yesterday. You disputed today. So I like to give them 90 days. Now, if you're 180 days or a year afterwards, I'd still pull your reports. Okay. Because we've seen errors stay on there for years at a time. And so, but I would not pull them. Let me rephrase this. If you're going to annual credit report, you can do that every 7 days. So it's no problem. Like pull them on day 1 and day 8 and day 15. But Innovis, you only get one free one. So I would wait to 90 days. Okay. And when you're watching this, if for those who aren't watching it live, the rules may change about annualcreditreport.com. I would definitely pull at 90 days. If you want to pull before, that's great. But what you would end up suing on or disputing, I would make sure that was pulled at least 90 days afterwards. Okay, let me check out our questions here. Archie says, do creditors have to notify me of negative information reporting CRAs after the account closes? I only know of my past due balances because of the credit report. So not really, not under the Fair Credit Reporting Act. They have to tell you at some point that they may report negative, but they always do that at the beginning of the account. So now there may be some other reason why the furnisher must tell you about a balance that's owed. But as far as under Fair Credit Reporting Act, if you see it on your credit report, then you want to just look and see, okay, is every piece of information on here accurate and complete? And if you weren't on some of our previous videos where we really kind of dissected credit reports, just let me know, or you can find those on my YouTube channel. Okay, so we've got clients been going through a situation, car lender reporting inaccurate information. We disputed, they fix it. Now it's all wrong. It's listed as charge-off. She has a car. Okay, so yeah, let me check on that. You said you sent me a message. I don't recall that, but let me check on that. We've been through a couple of days of mediation on some federal court cases, and so I kind of popping in here to do this webinar and then a YouTube live at 4:00 Central Time. So I'll check that out and say bankruptcy dropped the score by 300 points. That would be surprising to me that it would have that big of an impact on her. I'll say this: most people, kind of stereotyping, most people, so they're rocking along, okay, and they start to stumble, and they get 30 days and 60 days and 90 days, and late. Then they file bankruptcy. So a lot of damage has already been done. Now, occasionally you have somebody that is, relatively high credit score, but they know like the end is coming. Maybe they just lost their job and they can never replace it. And they're like, I better get ahead of this thing. So I guess it's possible you could have a really high credit score and then it drop, a huge amount. I'm not sure 300 points, but there's also all different sorts of scoring models there. Let's see. Merle asked, is there any document clearly tells what FCRA sections apply to credit bureaus and furnishers? So I'll say this. I don't know of a specific document for that, but in terms of the accounts, it's really the three that we've talked about. There's 1681E, and that applies to credit bureaus. There's I, which applies to credit bureaus, and there's S2, which applies to furnishers. Now, there's obviously a bunch of other sections, but in terms of like accounts, that's what we're talking about. Now, when we get into pulling credit reports, that's different. So somebody pulls your credit report, not talking about you, but somebody else pulls it. There are different sections there, and frankly, it's a little convoluted at first glance. We have to really decipher it. But those are the big three sections I would say to focus on: is E, particularly EB, and then I. Those are both for the bureaus, and then S2B is for the furnisher. Let's see. Jeff says, was bankruptcy in the New Testament called the year of Jubilee? Yeah, and I think it's really in the Old Testament. So that was part of the law of Moses, every 50 years. And then there was something I'd have to go back and look at it a little bit before then, where there would be sort of a resetting. Maybe if you were, like an indentured servant or something like that. But certainly kind of like family property lines would go back. And so that is part of the basis of bankruptcy. Let's see. Anthony says, can I sue Capital One? They had me pay for an account that was discharged in bankruptcy. So, I would look at your credit report, Anthony, and see what it says about that. Does it show that it was discharged? Because there might be some FCRA stuff there that you can do. But you would also want to get back with your bankruptcy lawyer and say, hey, can I sue under a bankruptcy discharge violation? Okay. And I just said this because you'll see these terms around. There's something called the automatic stay, and then there's the discharge. Well, what is it? As soon as you file the case, with exceptions we won't get into, there's the automatic stay, which it automatically pops up. That's why it's called automatic. And it's a stay because it's sort of like saying, freeze, don't do anything. So it tells all the creditors, stop. Okay. If you're in the middle of a lawsuit, stop. Okay. If you're about to make a phone call and you get notice that the person filed bankruptcy, hang up. Okay. Leave them alone. Well, that stay is in effect until you get to your discharge, and then it falls away. And now your discharge order is there, which says there's this permanent injunction, this bar, this barrier to collecting anything. So if Capital One called you and said, hey, you better pay this debt, and it sure sounds like they violated that discharge order, assuming they were properly notified. Okay, so I would get with my lawyer on that. Okay, so let me see here. Okay, so we'll come back to the questions in just a moment. So we've talked about pulling the credit reports, and now let's talk about, okay, we've pulled the right credit reports. What are the errors? And I've talked about this. I just want to reemphasize this a couple more times because it's really, really important to get this conceptually down. And then next week, when we look at reports, and again, feel free to email me your reports and just, say, hey, it's on page 37, or else just do the page that has the discharged item on it. And we'll go through those. Hey, is this reporting correctly or incorrectly? But let's get the theory down first. And so look at the balance. Is it zero? Well, then that's good. Is it blank? That's good. Is it something other than zero or blank? Well, then I would mark that down as an error. And next week, I'll give you a sheet that you can kind of use for each account just to document it as you're going through. But you would just sort of note that, like, hey, there's a problem here with the Capital One or the Midland Funding or whatever. And again, I'm not going to keep repeating this because I don't want to make this take too long. But all of this is assuming it's properly notified, it's actually discharged, and you did not reaffirm the debt. Okay. If you reaffirm a debt, sometimes we have the opposite problem where they won't report it. Okay. So we'll cover that in another session. But then look at the history. So, there's been a charge off. Now I discharge the debt. Is it continuing each month to show a charge off? That's going to be a problem. Or to show 30 days late or 60 or 90 or whatever. And then that credit pull. Did a company pull my credit report? Almost always for what's called an account review when the debt was discharged. Okay. If they did, and I have no other debt with this company, then they most likely did what we call an impermissible credit pull. And it means the credit bureau made a mistake. Okay. Now, whether we can sue the credit bureau for that, that's a different subject. We'll probably talk about that in a couple of weeks, but we can dispute that inquiry. And we can also sue. And sometimes we just sue. Sometimes we dispute. And when they don't fix it, we sue the credit bureau and the person that pulled it. That's called a user. So we've got the bureau, the furnisher, and then the company that uses the credit report. They go pull the credit report. They're the user. So we sue them. Other times we just sue the user without doing anything with the credit bureau. So different circumstances for that. Okay. So before I get to this example, let me go back to our questions here. So Morgan talks about debt collector says, I owe some money, asks them to verify. Contract has a lesser amount. So that's, it's a good question. It's not really on our subject of bankruptcy. I'll just say this. There's always a question, do you owe the debt? Okay, because if a collector's collecting a debt that you don't owe at all, that's a problem for them. Or if they're collecting this much and you only owe this much, that's a problem. If they just sent you the contract, did they send you any other supporting information which would show the actual amount? You may want to follow up with them and say, hey, you sent me a contract, it shows I owe like $28. How do you say I owe $628? And see what they do in response to that. Let's see. You got a question. Have you heard of LCI, refusing to give any information I have on my client? I'm not familiar with that, those initials. I may know the company, but that's not ringing a bell. Let's see. Brandon says, should the items included in discharge and bankruptcy still show up on credit report? I'll say it this way. They don't have to, but if they do show up, they have to show up accurately, which is no balance and no negative activity after the discharge. But the company could get notice of the bankruptcy and just say, we're deleting it. Now they can, every account I have on my credit report, whether it's in good standing, bad standing, today, every one of my furnishers could say, we're no longer going to credit report. So they don't have to credit report. But if they do credit report, it's got to be accurate and it has to be complete. Let's see. Robert says here about dispute. So I tell you what, Robert, if you'll get with me after the webinar and I'll go through that. Let's see. John said, copy of my credit reports. John, I think now that you say that, you may have sent those to me a few weeks back when we were doing the session. If you don't mind, send me another email, just remind me about that. Let's see. And hopefully I'm saying your name right here. Is it Javme? Let's see. Can they report a balance for a charge off and a collection on the same account? If they charge it off, how can they collect twice? Okay. So the short answer is I have a Capital One account and it goes to portfolio recovery. They both cannot say, oh, $5,000 because that looks like, oh, $10,000. So Capital One would have to say sold or sold to another lender, purchased by another lender. They would have to show a zero balance, okay? And that portfolio could show the 5,000. Here's where sometimes people get confused. I have to think in terms of a timeline, okay? So right now, today, Capital One has to show a zero balance. But going back before they sold it, they could show a $5,000 balance. So every month, 5,000, 5,000. Now they sell it. Well, they can't show a $5,000 balance, but historically they can show it. So just remember, theoretically, all credit reporting, we just sort of pick up each piece of information, each account, each little piece of every account, and we say, is this accurate? Is this complete? Now, if it's talking about June 2017, we don't say, is that correct today? We say, well, was that correct in June 2017? If it was, then it's fine to say. If it's not, then we challenge that. So hopefully that helps there. And LCI's new company reports bankruptcy to the credit bureaus located in California. Okay, that's interesting. So here's the deal with this whole this LCI, LexisNexis, SageStream was involved to some extent. I think SageStream is now merged into LexisNexis, if I remember right. But the deal is, so somebody can sort of wear multiple hats, okay? So this would be sort of a silly thing, but I am a father, so I wear a hat, okay? I'm a father, and I'm a lawyer, okay? I can be both, right? So a company can be a credit bureau. That's one hat they wear. They qualify as a credit bureau. There are hundreds of credit bureaus. We did a webinar maybe a month or so ago where we went through, here are 10 suggested credit bureaus that outside the normal ones that I, wanted you guys to pour your reports on. So LexisNexis may count as a credit bureau. Okay. LCI may be a credit bureau. I don't know. But they can also be a vendor. Okay. That's just a company that's hired by the credit bureaus. Go look at the court records. Okay. So they could hire Bob Smith to go look at the court records. That doesn't make Bob Smith the credit bureau. Okay. And so if you reached out to Bob Smith, he wouldn't have to tell you anything. But if Bob Smith or LCI or LexisNexis, if they're a credit bureau, then yes, you have a right to your full file disclosure. What we would call a credit report technically is called the consumer file disclosure. When a user pulls your credit report, that is what technically is a credit report. So hopefully that is helpful there. Let's see. Merle says Bank of America violated sections S2 to all three bureaus, counted as 3 counts or 1 count. In terms of a lawsuit, we would just have a count. So 1 count would be here's against credit bureaus. 1 would be against Bank of America. In terms of statutory damages, that is really when you get into willfulness, okay? And there's sort of a difference of opinion. Is this $1,000 total maximum or $1,000 maximum per violation? And kind of depends on where you are in the country. Okay, yeah, see, D says SageStream is now LexisNexis. Okay, very good. So let's go through some examples here. And hopefully we have done a good enough job in presenting this that you guys will see this and we'll just knock these out here. So here's the example. Capital One, $5,000 balance. It's charged off. Then after it's charged off, I file bankruptcy. And then December 2021, I get a discharge and I don't reaffirm the debt. The Capital One debt's discharged. And now in March, it shows a balance of $5,000. So what do you say about that? Is that right or is it wrong? And yeah, John says it's wrong. I mean, it shows a $5,000 balance. It's the reason it's wrong is I don't owe the money anymore. There's that discharge order. Okay. There's no way Capital One can say I owe the money. Now, again, there's a few judges that I think really got off track who say, well, even though you may not be forced to be able to let me rephrase that. Even though Capital One may not be able to force you to pay it, it's still okay to put it on there. But that is by far the minority position, and I think just totally unsupported by the law. Okay, in my view, the law is absolutely clear that they cannot show a balance on there. Okay, now if they're showing a balance before I file bankruptcy, that's fine. Once that discharge happens, and there's a little bit of disagreement about what about from when you file the case to the discharge. I'm just keeping this very clean and say, go to that discharge because that's when a court says you do not owe the debt If they're showing a balance after that, that's a problem for them. Yeah, Jonathan said should be zero. Absolutely. Then Ken says, how do we retain your services as fee paid by the entity we're suing or us, the plaintiff? So we don't charge anything. You don't pay our hourly rate or out of pocket or anything. We sue the bad guys, and then out of that settlement, we get our money. Sometimes there are what are called court awarded fees, but I'm going to say 99% of the time, it's just a lump sum settlement, and then we split that up. So if you have any interest, I can talk to you about that offline. Let's see here. So we've got, so on the issue of bankruptcy itself, whether that should be on your report, we're really not covering that here. The simple answer to that is we find errors with how the bankruptcy itself is reporting. So the court, the date, the file number, the date file, the date discharge, just like anything else on our credit report, we just look at every piece of information. And there are some strategies about LexisNexis, and I won't go into those here. Let's see. John says there's a difference between filing Chapter 7 bankruptcy and going through it all the way versus filing to not go through. Yeah, if you don't go through it, there's no discharge. It's just dismissed. And sometimes those words sound similar, a world of difference. Okay, it's kind of like a collection lawsuit being dismissed with prejudice or without prejudice. Totally different thing. So you have to go through the bankruptcy to get that discharge to get the benefit of what we're talking about here. And let's see, really scenario where there's a discharge without filing bankruptcy, or discharge only happens after bankruptcy. That's a good question. I'll say this. So we have to be a little bit careful, because sometimes, again, words either are the same, but there's different meanings, or they sound similar. So you have a charge-off, totally different than a discharge debt. Now, just the word discharge, I'm using that in the sense of bankruptcy context. We can have a situation where there's a 1099-C filed by a creditor, so saying that you owe taxes on this forgiven debt, and that can be because the debt has been discharged, okay, outside of a bankruptcy context. Courts are split on that. I've done some videos on that. We can have maybe we have a federal student loan and we go to some crooked, fraudulent school, and then we apply to the Department of Education and they give us a discharge of that debt. Well, again, that would not be bankruptcy, but what we're talking about here is only about bankruptcy discharge. Okay, so nothing else, only bankruptcy discharge here. And let's see. John says if it's dismissed, the reporting from the accounts the same. Yeah, if the bankruptcy is dismissed, it should be as if you never filed bankruptcy. I mean, you're going to have the bankruptcy itself on your credit report. It'll just say it was dismissed, but the accounts, for the most part, should not be affected by that. And so we'll come back on some. So let's go now to our second example here, which is I've got a Discover card. I owe $3,000 on that Discover card. It's charged off, and I filed bankruptcy in September of 21. I get my discharge, and immediately Discover card updates the balance to say zero. I mean, both like the current balance, but also in the historical, as of September 21, it shows a zero balance. Okay. But then look at this chart here. Before September, it shows the rating, which is what TransUnion calls it, the payment history, Experian and Equifax, says charge off. Is that right or wrong for before September to show it as a charge off? What do you think about that? So discharge in September, and we're talking about before September, like August, July, June, it shows a charge off. Is that right or is that wrong? Okay, Kimberly says right. Yeah, and that's correct, because again, when we look at each piece of data on the credit report, we say, was this accurate and complete at the time it was reported? Okay. Now, if a credit bureau or a furnisher learns that they reported something incorrectly, now they have to go back and fix it. Okay. But back in August or July or June, they could say a charge off because I had not gone through my bankruptcy. But now we get to October. So discharge under bankruptcy in September. October, they show a zero balance and they show a charge off for the month of October. You've seen the charts, right? And it's got, January, February, March, April. And so here in October, it says charge off for that month. Is that correct or incorrect? And why do you say that? Yeah, I'm sorry. We had a bunch of other people on the one before September saying right. So that, yeah, very, very good. Okay. So, what about October? What about November, December, January? These months after my discharge, can each of those months, can they report charge off, charge off, charge off, charge off? And so what do you say? Yes or no? And then tell me why you say that. And I realize we have a lot of people on here that may be driving or, you can't jump in the comment there. Let's see. Archie says, should it say settled or paid? So remember, the debt was discharged. So I didn't settle it. I didn't pay it. I just literally discharged it. And let's see. John says, be wrong until January. Yeah. So anytime after September, they should not be showing for each month after September that actually not even for September, that they should not be showing a charge off. Okay. Because I discharged the debt. So once that discharge happens, I no longer owe the debt. So I can't be 30 days late on something that I don't owe. So remember, if the discharge happens here and then the next month, can they report me as late? No, because I don't owe anything. Can they report me as 60, 90, 120, 150, 180? No. How about charge off? No. I can't be charged off if I don't owe anything. The debt instead has been discharged under bankruptcy. And so, yeah, we've got a lot of people here kind of saying the same thing. So just remember when you're looking at this, and again, next week we'll put up some actual credit reports and kind of see exactly what we're talking about. And if there may be a reason I can't use sort of a real credit report on a particular situation, I'll just sort of recreate it, but I'll show it to you. So just remember that timeline. Discharge happens. Anything going forward in time after that, it cannot be reporting negatively. Now, going back in the past, it can, because that's true. But going forward, it cannot be saying every month, well, I'm 30 days late or 90 days late or 150 days late or even charge off, because I don't owe anything anymore at that point. Okay, so let's look at this credit pull. And would this be a permissible purpose or not? So I have one account with Synchrony Bank, discharged December 21, and I don't apply for anything with Synchrony. I don't have any accounts. They don't take over any of my other credit cards. I got nothing. Okay, nothing with Synchrony Bank. And so this month, March 2022, they do a soft credit pull and they say, we did that as an account review. Right or wrong? Do they have a permissible purpose, or did they have no right to access my credit report? And if it's a soft pull, does that even count? So what do you think about that? So we got John says it's wrong, impermissible purpose. Joe says wrong. Yeah, everybody's saying wrong, no authority. Yeah, I think you're right on that, because, and again, we'll cover this in detail. It really will take a whole sort of seminar to do this. What is a permissible purpose? Some things are easy, right? I go into the car dealership, I say, please pull my credit report to see if I can get a loan. Okay, they have a permissible purpose. I don't always have to give express permission. A lot of times, actually, if you look at the vast majority of times on your credit report, you gave them no sort of express permission. But just the fact that you have a Capital One credit card or a Synchrony credit card, they have the right to pull your credit report and do this account review. Now, it's a soft pull. Traditionally, defendants have argued, well, a soft pull is, that doesn't matter. Well, here's the interesting thing. The FCRA makes no distinction between a soft credit pull that does not affect your credit score, and a hard pull that often will affect your credit score. That is something that's more of a scoring deal. That's not in the FCRA. The FCRA just says credit bureaus shall only allow users to pull your credit report if they have a permissible purpose. It's sort of stated the other way. If you're a user, you better only pull a credit report if you have a permissible purpose. Well, here, I've got no relationship with Synchrony Bank. So they say, well, we did an account review. A review of what? I have no debt with you anymore. It's been discharged. Okay. Now, you may recall a week or so ago, I did a case review where somebody lost this issue. But the thing was, they had not properly notified the furnisher. And so that gave the furnisher really a way out of this. Okay. So again, all this is assuming we properly notified the furnisher, or I'll just say the creditor here. And now that creditor says, well, I'm doing an account review. Well, my account's been discharged. Now, if I had 3 other Synchrony Bank accounts that were not discharged, well, they would have the right to pull my credit report. Okay. But this is something that it's sort of subtle in a way, but if you've gone through a bankruptcy, you want to look through those soft credit pulls and see, okay, well, why was Capital One pulling my credit report when I don't have a Capital One account anymore? And again, you want to look at the date. Okay. So if they pull it on, January 1st and January 5th, I get a discharge. Well, that's fine. Okay. Because until the discharge, that debt was still good. But they pull it after January 5th, or in my example here, back in December, that's a problem for them. So hopefully that makes sense. Let's see. Archie says, what happens? Let me get this out of the way. What happens when car dealers give it to other places? So, and we'll talk about that in our class on permissible purpose. Okay. In other words, there's a car dealer. Can they only share that with one lender? Can they share that with 57 lenders? Okay. And what's kind of the time period of that? So we'll talk about that because that's definitely important to do. Okay. So we're right at about an hour here. And so we'll wrap this up as quickly as we can. So here are some options, and I'll have a handout for you next week, just a PDF that you can either, mark up on your computer, your tablet, or print out and just do it by hand. But you really want to say, okay, I did a dispute. Okay. I found these errors and I explained them. And I'm not going to go over, how do we prepare dispute letters other than say that we have a ton of that on our YouTube channel. And the bottom line is there's no magic language for dispute letters. You really just want to explain what's wrong. So you can say, hey, Capital One and Equifax, Experian, TransUnion, why are you reporting a balance on my Capital One account when I was discharged here and I just looked at my credit report 90 days later and it's been updated and you're reporting a balance? Why are you doing that? Here's a copy of my bankruptcy petition. Here's a copy of my discharge order. Get this off. Okay. So assume you do all that. Then you go, okay, was each error fixed? Now, if each error was fixed, then we're not going to have an S2B claim. So remember when I was talking with Merle about that, S2B is for the furnisher. We're not going to have an I claim. I stands for investigation because we asked them to investigate and they fixed it or they deleted it. But we might have an EB claim. Okay. Now, I'm always telling lawyers, be very careful about filing those claims. Okay. So it's got to be done very carefully or they can really blow up in your face. But there's that option. But now if they don't fix a particular error, well, then you may have that S2B, that's the furnisher, and the I claim. And then we always throw in an EB when we have an I claim. I claim is, hey, credit bureau, you did a lousy investigation. I filed bankruptcy. I sent you the information and you verified this $5,000 Capital One account. What are you doing? Okay. And then you want to make sure your dispute is clear. In other words, your letter, was it clear? Did you make it crystal clear what you're disputing? Was the notice in bankruptcy, was that clear? Was that proper? So I have people come to me like, oh, it's a great lawsuit. And I get to looking through the bankruptcy thing. I'm like, we never notified this company. Oh yeah, I just forgot about that. Can we sue them? We got to notify them properly. Okay. And then again, I have on this chart, just the bureaus are E, B, and I, and furnishers are S2B. And if it's a debt collector, you might have that E8 claim, that section 1692 E8. Okay. So here's an action plan for you. If you're in this situation, maybe you filed bankruptcy 6 months ago, got your discharge 6 months ago. So start off, look at your bankruptcy petition, and your lawyer will have that. Bankruptcy lawyer will have it. Did you list all your debts correctly? Or you're like, I left off 3 debts. That may be a problem. It can be fixed, but it certainly is better if they're listed properly. Was notice given? Okay. So maybe we listed the debts, but we gave the wrong address for the company. And so the bankruptcy court sent notice to the wrong address. Well, that would be a problem. And then pull those credit reports at that 90-day mark. Okay, so Equifax, Experian, TransUnion, Innovis. And then for each account, just it's like you pick up each account, you're looking at it, and sort of walking around and saying, does this show a balance that's more than 0? If it is, let me write that down. That may be a problem. Does it show negative history after the discharge? So negative, I discharged, and then does it show negative going forward in time? Well, that's going to be a problem. You write that down. Is this the only, do I have a company that pulled my credit report and the only account or the only accounts, if I had more than one, were all discharged? Well, then why are they pulling my report? Again, assuming I'm not like applying for credit with them. You write your dispute letter, send it certified mail. I use a company a lot of times that is certifiedmaillabels.com. I don't get anything from mentioning this company to you. I just have used them. I find them to be very good. Now, we also send out a lot of letters, but you go to Certified Mail Labels, you have to set up an account, and you come down here to print and mail services, and they say, hey, do you want us to print something? Like, yeah. And then you say, I have a single letter, okay, just to keep this easy. Well, then you label that letter, you say how many pages it is, you upload it. You can have across the top or across the bottom, you can have on each page the certified mail number, which is pretty nice. And then you upload it, it'll get you to approve it. And then you say what your address is, where it's going, and you can look at it before it goes out. And, it's a couple bucks more than going to the post office, but if it's the difference between getting it out or not getting it out, and if you're doing a volume, this is so much easier because it just tracks everything. So that's something that you can use. Going back to our little action plan here, if you send it certified mail, they'll get it 3, 4, 5 days. And then they have normally 30 days to investigate. Then they'll respond back to you. Well, that may take, a week or so. So I tell people, usually think 6 weeks. You should be getting some responses in 6 weeks, and then fixed or not fixed. And if it's not fixed, or if you think that it was just a blatant error to begin with, let me know. I'm happy to look at this stuff and see. And I'll say this: normally, I am. How can I say this? I'm reluctant to look at credit reports because I have enough of my own with clients in Alabama. But if you've done the disputes and you feel like it's not been resolved, then you're welcome to send that to me. Just send me kind of a package with a summary of what's happening. Here's what it looked like before. Here's why I disputed, how I disputed, what the results were. And now I pulled my credit reports again. Here's what it looks like now. And then I can tell you, hey, I think that you have a potential lawsuit. And depending on where you are in the country, we may file it. We may get somebody else to file it, may co-counsel with somebody. So just keep that in mind. But what I wanted you to get in this class is really just the theoretical understanding of what is a discharge, and those 3, when I say common, I don't mean that's like every single account is this way. It may be, 75% of people have one of these errors, but then you'll have one person has like 6 of these errors. Okay. So there are some people that there are no errors on their credit reports. That's perfect. But you need to know because you paid the price for that bankruptcy, so get the benefit of it. And then just next week, I mentioned this, and then I'll come back to the questions here in a moment. It'll really be going through examples, and I'll put up the thing, and I'll say, okay, assume the discharge happened such and such date. What do you see about this reporting? Does it look accurate? Not accurate? And again, I have my own that I can do, but I would really prefer if there are those of you on the call that have filed bankruptcy, send me your reports or the pieces of your report. If you run a credit repair place, you say, hey, I've got 4 or 5 clients with this, we'll just pull out the individual accounts that you think there might be an issue with and send those to me. And again, I'll redact the personal information and we'll just go through it together. To me, that's the best way to learn it. And then just have some questions. And so now let me, in our remaining minutes here, let's look at our comments here. So Murley says, would it be okay for Synchrony to soft pull after charged off but not discharged? Yes, because charge off does not make the debt go away. Charge off is just an accounting function. And this is something that there's a lot of bad information out there. Oh, if they charge off a debt, you don't owe it anymore. It's absolutely untrue. Every court says a charged off debt is still owed. Now, there's a split in authority among courts. What if they issue you a 1099-C? That's different than charged off. Okay, not to make this confusing. 1099-C, they'll say that is discharged debt. They don't mean necessarily bankruptcy discharge. They just mean we're not going to collect this debt. Okay, but just normal charge off, yes, Synchrony Bank would still have that relationship with you, and they can still pull for the account or even for collection purposes. Okay, so let's see. Chigozi says webinar 1 p.m. or 2 p.m. on Thursday. So it's 1 p.m. Central. I think you're in Eastern time, so it'd be 2 p.m. every Thursday for you. And John says, can co-counsel another state if we have a great case? Yes. And so we do that from time to time. Kind of 2 ways to do it. I won't necessarily say the best way. Usually the simplest way for our clients is if they have a lawyer in another state, and then we can jump in the case with that lawyer who's licensed in the client state, and it can be filed there. But particularly with COVID, everything has gotten so remote and people are used to doing things, Zoom and all that sort of stuff. So there are times where we'll have somebody in another state and we'll say, well, we'll file your case in Alabama. Always a chance it gets moved. If it gets moved, we get a local lawyer. If it stays in Alabama, then we just, represent the client. So yeah, we're always interested in looking at cases that there's, actual errors. They've been properly disputed, and then it hasn't been fixed. And just for full disclosure, one reason I did that 6-part webinar series that you may have been on it, this was last year, and I've also put it on YouTube, is I did that to share information, even if nobody ever contacts my firm. Totally fine. There's no obligation. Okay. I didn't put this behind a paywall and say, pay me $797 for the 6-part webinar series. I just said, here it is. It's free because I want to help people. And frankly, there will be people that will actually do their disputes the right way, which greatly increases your chance of getting everything fixed. But when they don't fix it, now you have a great lawsuit. Okay. And I'm not opposed to people coming to me saying, hey, here's what my credit report said. Here's the great dispute letter I wrote. And here's where they didn't fix it. And now my new credit report shows it still has that bad information. Wonderful. Let's talk. Okay. So let's see. Jonathan says, I'm in the middle of chapter 7. My student loans have been deleted from my credit reports. Will they reappear after the other debts are discharged? That's a really good question. We do see some companies, when they get notice of the bankruptcy, they just say, you know what, we're deleting. Part of that is, I think I might have mentioned that it's a little bit of a gray area between you file bankruptcy and your discharge. So you file bankruptcy, can they report you 60 days late the next month when you're in bankruptcy? There's a little bit of doubt about that. The safest approach, if I was advising companies, I would say, get it off the credit report, because all you can do is mess it up and get sued potentially. So some companies do that. They might reappear, okay, after the discharge, or they may stay gone. But keep in mind, and I think I've talked about this in other videos, you have the debt itself and you have the credit reporting. The debt itself is sort of the critical thing, okay? If the debt itself is gone, then the credit reporting has to reflect that, okay? So if it's discharge, the credit reporting has to say discharge. But if we delete the credit reporting, but the debt's still valid, the debt is still there. So the debt is what controls, okay? So just because it comes off our credit report doesn't mean that the student loans, for example, are discharged. You'd have to get with your bankruptcy lawyer about that. Okay, John says, if Macy's been reporting my credit reports negatively for past 6 years, could this be a rather large violation due to being willful, damaging my credit reports? In a way, but I'll say this. You have to dispute to be able to sue Macy's under the Fair Credit Reporting Act. If you dispute and they don't fix it and they're negligent, you can sue them. If they're willful or reckless and not fixing it, you can sue them. But at that point, you basically have 2 years to sue. So you wouldn't really go back 6 years. And the law is strange under the FCRA for what willful means. I think maybe you mentioned it earlier, John. How do you show something's willful? Well, you would show that it's absolutely clear from the law, and they chose a different path. Okay. But if there's sort of some ambiguity, what's going on, then a lot of times courts will let them off the hook for that. They'll still let you sue for negligent violations, and you get damages for that, but you don't get statutory, you don't get punitive damages. Great case out of the 11th Circuit called Losch, Losch. Let me see if I can pull that up for you here. I did a video, which you can find on my YouTube channel. But let me see here if we can pull up. And if I can, I'll drop the link in the chat. Let's see. This is one way to get to it. Put this in the chat. So this is what's called Justia. And let me share my screen here just to show you. So this came out. I'll get this to expand here. Okay, here we go. So it came out April 28th of last year. It says NationStar, but the lawyers and the plaintiffs settled with NationStar. So it's really against Experian. And let's see here. It's a little bit complicated. It's a Chapter 13, as I recall. And like the person reaffirmed the debt, and then they rescinded that reaffirmation. So it gets a little complicated. But ultimately, let's see, discharge. Okay, filed Chapter 7, discharged his debts. It showed he was delinquent. He contacted them to correct it, but they didn't fix it. And let me just show you a couple things on here. So it showed his debt. Let me make this a bit bigger, so maybe that will be easier to see. Well, anyway, take a look at it, and it's showing he owes $140,000. He's $10,000 past due. Ultimately, the court said this violates the FCRA, but my memory is the court said this was not willful. Let me just glance back at this. Yeah, they say that this was not a willful violation. Now, it's not to say the next one won't be willful, but it's a pretty high standard there. So let me go back to our questions here. Ronald says, when you send a certified mail, do you have to have the signature card, online signature, just the USB showing it was delivered? I always do the signature. Now, that got a little weird with COVID. A lot of times, we were all afraid to be around people, apparently. So, the mail person would just write like COVID-19 on the signature line. But it's a couple bucks, but I always do that just to try to get around the argument. I've seen companies lie about getting certified mail, and I'll just tell you, there's one bureau in particular. I think this year the lawsuits against them, they never answered any of our disputes, and that's with certified mail. So you sort of get the idea. You want to be really, really solid to show that they got this, because their initial reaction is to say, "Oh, we didn't get it," and they go, "Yeah, it was delivered." Well, a thief came in and stole it. We didn't get it. So you want to be able to show the signature. All right, let's see. Question about helping people in Illinois. So, not directly. I'm not licensed in Illinois, but again, I have had clients in other states that we end up suing in Alabama, depending on who we can sue. It might be a local company where you have to sue in Illinois, but if we're talking about like Equifax and Capital One, I mean, we can sue them anywhere. Now they might transfer it, and if they did, we would co-counsel with a lawyer in Illinois, or we could start off doing that. So that's certainly a possibility. Let's see. Murley says, if I write as below, if the disputed debt's canceled in full, Bank of America reports TransUnion that the balance is zero. I'm willing to release any and all FTC, CPA, FCRA claims. Does that mean I admitted to owning the account? No, I don't think so, because you said disputed, and yeah. So I mean, let me say this. Every state, you'd have to look at it individually. In Alabama, I would not be concerned about that, because first of all, this is settlement negotiations, which are not allowed to be brought up in trial. And you point out that it was disputed. Okay. Let's see. John says, if it's true that after so many years, bankruptcies aren't as high of a hit on your credit reports, yes. So really, any negative information, you kind of think about it this way. We start off over here, and it, as soon as it happens, it's bad. But every day, every year, every month, it starts sort of declining in the negative effect. So you can imagine, if I have a 30-day late for February, well, that's going to be more damaging to me than a 30-day late 6 years ago. A creditor looking at me is going to say, yeah, 6 years ago. I mean, it's still negative, it's still bad, but like time is the great healer. Okay. But yesterday, that's really, really bad. Okay. Bankruptcy yesterday, devastating. Bankruptcy 6 years ago, not as devastating. I forget what it is. There may be some mortgage brokers on the webinar. I want to say for like a FHA loan, it's either 2 years or 3 years after discharge that you need to be. So before then, you could have a fabulous credit score, but you're just not going to get through underwriting. But after, it's either 2 or 3 years, I think you can qualify for a mortgage, assuming your credit score and everything else is good enough. See, Sylvia says, can debt collector has lawyers file suit for original creditor, say Discover, and list Discover address, the debt collector address? The lawyers don't claim to be debt collectors, although they're registered. Isn't there a lot wrong with suit files? So let me say this. So let's use some names. Let's say Midland, okay, a big debt buyer, and it's Jones and Smith law firm, collection lawyers, and they file for Midland. If they say, at least this is true in Alabama where I practice, if they put the plaintiff is Discover, and I've had that happen before, where they lie and they put the original creditor instead of the debt collector, then that's a big problem. Okay. We're typically going after the debt collector and the lawyer for that. But if it says Midland Funding as assignee of Discover Bank, well, that's assuming that's true. That's not wrong to put that. Okay. So we just look at the lawsuit and say, is it truthful? Or are they trying to trick us with who's really doing this? Now, as far as the lawyers, whether they say they're collectors, they may not be debt collectors under the FDCPA. Just because a lawyer files a lawsuit, a collection lawsuit, does not make that lawyer a debt collector. It has to do with the number of cases, the percentages. It gets a little complicated. But I would say this: if you've been sued, you really need to get with a consumer lawyer in your state. And I know at my firm in Alabama, we talk with people in Alabama, even if they're not going to hire us. We'll give them some thoughts. Hey, be careful about this or that. And we don't do that for anybody in another state. Well, let me take that back, except for Tennessee. Blaine Dixon, who's a great consumer lawyer, is of counsel with us. And so he practices in Tennessee, has his whole career. So if you're in Tennessee or Alabama, we would talk to you. But other than that, you need somebody in your state because every state is different. And the rules, the customs, the way the judges act, on these collection cases, you really have to have somebody local there. So I would just talk to a lawyer and find out, does this look right or does this not look right? And they should be able to tell you pretty easy. Okay, Ken says, LexisNexis deleted the bankruptcy. I sent that letter to the credit bureaus. They still did not delete the record. How do you deal with that? Okay, so let's take a moment and talk about this. So here's the theory. And it's not a bad theory. I think it's, for a lot of people, it's probably more work than it's actually worth. Okay, so let me give you the theory. Here's how you delete bankruptcies. So we're not talking about discharged accounts. We're talking about the bankruptcy itself, the public record. What you basically do, there's variations on this, but you go to the bankruptcy court and you say, do you guys provide this information to the bureaus? And a lot of times they'll write you a little letter, kind of form letter, to go, we provide no information to the bureaus. So you take that, you dispute with the bureaus, and then they come back and they say, we verified this with the bankruptcy court. Well, the bankruptcy court says we don't verify. They're not a furnisher like Capital One or Discover. So then you find out that they use LexisNexis or I forgot who mentioned it, LCI, apparently a new company. And so you go to LexisNexis and you say, hey, I want to opt out of your credit reporting. I want to freeze my account, all this stuff. The theory being that now when you dispute with Equifax and Equifax goes to LexisNexis, LexisNexis will be unable to talk to them. I'm not saying it never works, but it works in spite of this. It doesn't work because of this. LexisNexis, they put on their hat that says, I'm a vendor, just like Bob Smith, who they paid $10 to go look at the courthouse. You can't make LexisNexis not do that work, okay? Now, whether you can sort of opt out or freeze your LexisNexis report really has nothing to do with LexisNexis being hired by Equifax to go check out the bankruptcy. Now, again, it can work. You can send a dispute on pink paper with green ink, and that can work. Doesn't mean it works because of that. So we always have to understand the difference between correlation and causation. Okay. Correlation is I wore my lucky socks and I won the lottery. Okay. Well, that probably wasn't causation. It just so happened to be. Okay. So again, you can do this, and I'm not saying, it's wrong to do it, but I'll say from my standpoint, as far as suing, I don't like my clients disputing stuff that they know is correct. I mean, at the end of the day, did you file a Chapter 7 bankruptcy in the Northern District of Alabama on this date, and you had a discharge on that date, and this was your case number? If the answer to all those is yes, and you do this LexisNexis dispute and pink paper and green ink and double-sided, and they don't fix it, I'm not going to sue for that. And the problem is, for my firm anyway, even if you have legitimate stuff, I might say, well, I'm not going to sue because you did this sort of, bogus thing when you knew all the information was correct. Okay. So I don't like it. I also don't think it is particularly helpful, because if you file bankruptcy and then 4 years later, let's say you delete it off your report, you're applying for a mortgage loan and you lie, that's a felony. Okay. Don't lie on your mortgage loan. Okay. So, and besides that, your mortgage company, they have other records they can check, and they'll see the bankruptcy and then say, hey, why are you lying about the bankruptcy? Okay. So I don't think it really does much good. So, but again, you can do it. Just understand that at least for, my firm and any firm that's like my firm, that may hurt your credibility enough that even if you have legitimate stuff, you know, cap one, you get a discharge, they're reporting a balance, you dispute it, they don't fix it. I may look at you and say, yeah, I'm not going to do that because your credibility's shot because of this whole bankruptcy LexisNexis thing. Now, if you find errors on the bankruptcy, so it's got the wrong date filed, if it's off one day, that's wrong. If the discharge is wrong, if the case number is wrong, if they say you filed it in the Eastern District of Tennessee and really you filed it in the Western District, that's wrong. Dispute that. Okay, that's what I would rather see people dispute, are the actual errors. If it doesn't get fixed, you may can sue for that. So anyway, that's my little rant about that. I'm not going to say anything more about that. All right, so John says, if attorney for a debt collector has been charging me exorbitant fees, can I request a billing statement? Is it legal to charge me to request this, cost them time? So if you're the consumer and there's a lawyer representing a debt collector and they're charging you fees, well, if they sued you and won and the court awarded those fees, then, you know, you got to pay it. If they're just saying, if you want to settle, you have to pay these exorbitant fees. You can always say, I'm not going to settle. You know, if those fees are not allowed by the contract, then that may be an FDCPA violation because they're collecting an amount that's not owed. If you go to the collection attorney and say, hey, give me a breakdown of my payments, and you know, he says, well, I'm going to charge you $100 for that, I would just, you know, make him put in writing why he's charging me that. And then I would probably just send a letter and say, I'm sending this under the FDCPA because I think you're overcharging me and I want you to show me the proof. And I'm not paying you anything to show that to me. And if he refuses to do it, you may want to sit down with an FDCPA lawyer because you may can sue them for doing that. Okay. In other words, if you say, look, I think you're violating the law, you're charging me too much, and they won't look at it, well, then it's, if they're wrong, that's a problem for them. All right, let's see. Ronald says, not on bankruptcy. Answer if you have time. My mortgage loan has my house note, insurance, and property tax included in a monthly payment amount. County raises the property tax, which is higher than what was originally my monthly payment. I wasn't notified. Credit score dropped because it's showing the extra amount has been short in the payment amount. Should that happen? So the answer is no, that should not happen in this sense. Your mortgage company should notify you if your payment goes up, because what's happened is the escrow has changed. And they're supposed to tell you, hey, you know, there's been an adjustment with escrow, so you were paying $1,600 a month. Now you need to pay $1,650. Okay, and the reverse, you know, hey, now it's dropped. It's now $1,550. If they didn't notify you, then that's not really an FCRA violation, but under RESPA, RESPA, you can send what used to be called a qualified written request, QWR. We now call them request for information, RFI, or notice of error, NOE. And you have to look on your mortgage statement. There'll be a special address. It's mission critical. Find that special address or call them or look on their website. If you send the perfect letter and they get it and they ignore it, but you send it to the wrong address, like you send it just to the main address or the correspondence address, it's worthless. If they have a special address for a QWR, notice of error, request for information, you got to send it there. And you know, ask them for this stuff. Request for information is you're requesting information. Hey, give me proof that you notified me of this change. And notice of error, hey, I think you made an error. I'm giving you notice of it. You raised my rate without notifying me, and I've been paying the amount you told me, and now you've reported me as late. So I want you to fix all these errors. You know, get rid of late charges, fix my credit report, blah, blah, blah. So that's under RESPA, okay? And you might want to get with the lawyer who does RESPA law in your state to help you with that letter. Let's see. Sylvia says MD, so I'm assuming Maryland. And yeah, both you guys are welcome there. And so here's Jay says, thanks for shutting down all the fake credit gurus out there giving false information. So Well, I appreciate that. I'm not sure I'm shutting them down because, they do these crazy videos and they'll have like 50,000 views and it's just complete garbage. So what I would say is whatever information that you see online, whether it's from me or anybody else, check it out. And that's why a lot of times I take the time to say, well, let's go look at the case law, or let's look at the statute. And where a lot of these people that are giving out wrong information, I don't think it's intentional. At least I hope it's not intentional. They may be looking at the statute, but they're not looking at the cases, or they look at one case. And it would sort of be like, you know, I go to an orthopedic surgeon and I say, I know more than you because 17 years ago, my cousin had to have some back surgery and I did some research on it. So I know more than you do. Well, maybe let's just pretend maybe I know a whole bunch about that one type of back surgery, but I don't know everything and I don't know how everything interacts. And maybe if you cut here, that's going to cause neurological problems. So where we see people get in trouble with is they have a little bit of knowledge about the FCRA or FDCPA and they sort of exaggerate that knowledge and they have no idea what they're doing will just have terrible consequences for people. And so and I'll just say this, anybody that's in this business, if you want to be telling people what the law is, you can't just sort of skim the FCRA or, oh, I heard somebody say this, whether it's me or anybody else. You've got to dig into it and you got to put in the repetitions. By that, I mean, you got to read the case law. When I decided, so my background is personal injury, and I had done a few cases against credit bureaus and things like that in the early 2000s. And in about 2005 or six, I said, I'm going to really develop this area of the law because I had some personal experiences with it that were just, shocking to me. And so I went to a 3-day seminar on it. Okay. I bought a book. It's called NCLC Manual. It's like the best book on this. But then I took in the 11th Circuit, which is Alabama, Georgia, Florida, I printed out every single appellate court case from the 11th Circuit that had to do with the FCRA. I printed out every trial court, what we call district court and federal court, every district court case in the 11th Circuit, Georgia, Florida, Alabama, I mean, hundreds and hundreds and hundreds of cases. And I sat there and I read every single case. Well, why did I do that? Because if I wanted to do this, I wanted to know it, not just have some surface level, amateur level knowledge, but I wanted to be a professional about it. And if we're going to advise people on this, you got to put in the work. I read cases every week. I've been doing this. I started teaching lawyers this, I don't know, more than a decade ago. Okay. In a way, I could say, you know what? I don't need to read any more cases, but I read cases. Why do I do that? Because I want to stay up on this. Judges change, theories change, defenses change. And so if we're going to do this, we have to put the work in. There's no shortcut to it. There's a whole bunch of work if we want to do this type of law. Now, if you're just doing this for yourself, you don't have to do that. But I'm just saying, when you hear somebody going, oh, well, it's illegal to report late payments. And I like, wow, that's amazing, or, all credit bureaus are illegal. Well, maybe the Supreme Court would know that. They just did a case involving TransUnion, and somehow they didn't know all credit bureaus are illegal. So people just sort of make these outlandish statements because you have to make an outrageous statement to sort of be heard above the noise. And that's great if what you're trying to get are, views or likes or people to Venmo you money. But if what we're trying to do is really rock solid information and know this, then it doesn't matter whether it's flashy or not. We've got to just put in the work and the time. Okay, so Ryan said, took a 6-part course you did, fixing your credit, use that information, help a client dispute 9 negative items, happy to report spreadsheet really worked, helping find the inconsistencies. Some were not fixed after that dispute. Okay, well, that's interesting. And Ryan, if you would, get with me. I'd like to hear more about that. So, congratulations for going through it. I knew as I did that course that, most people would not actually do the work. It's why, if we're trying to lose weight, we look around, we like, I got 17 diet books and 12 exercise books, and I'm, reading another book while eating, M&Ms on the couch. So, there's a difference between knowing things and taking action. So I'm really happy that you took action there. And let's see, Eric says, long being sure of the law's explanation, please, please, please tell clients it's not legal advice. Yeah. So if you're in the credit repair space, I would be very careful about saying to a client, this is what the law says, because what you've done by that, just as an example, is you've given legal advice. And by doing that, if you're wrong, this is a client, this is not just some stranger, somebody asking you, but like you're telling, your client, oh yeah, you can ignore this, or you can do this, or you turn down that settlement because you're going to get more money. I'm an expert on the FCRA. It turns out you're wrong. That client may sue you for legal malpractice. You go, well, wait a minute, I'm not a lawyer. Well, then you shouldn't have acted as a lawyer. Okay. So what Eric's saying is very good. Just, I don't, I'm going to say this. I've taken doctors' depositions. I know a lot about medicine and surgery because I've taken doctor's deposition. I don't think that makes me a doctor. Okay. I know a whole lot about appraisals and real estate and valuing stuff. That doesn't make me a certified appraiser. Okay. Doesn't make me a licensed real estate agent or broker. So we kind of need to stay in our area and just be careful about, definitive statements, because there are very few things that are just absolutely 100% in the law. Let's see. John said, you're able to help me sue someone in New York, hired to help me with my credit reports, did nothing for 10 months, asked her for proof of mailing. She had none. That's pretty typical. Okay. If you ever hire a credit repair, I would always insist that they send me copies of the letter. I mean, the letter has my name on it, right? They're sending it out as John Watts. I think I'm entitled to my own letter. Okay. Because what we find is we'll have credit repair places that don't know what they're doing. And there are places that do know what they're doing, but the ones that don't will say things like, this is not my account, when it really is your account. There's like 27 errors on there and they put not my account. You just gutted your credibility. Or even worse, go fill out a fraudulent fraud affidavit, bogus fraud affidavit, get a bogus police report. Now you've committed a crime. Not a good look. Okay. So, all right, ask for proof filings, numerous negative feedback. So here's the deal with that. It sounds like she did lots of violations. Generally, the people that are doing that, they're not a real business. There's really nobody to sue. Okay. And they may have sort of a flashy lifestyle, at least the appearance of it. It's like, I'm sure you've seen people that they'll do like Instagram pictures and I'm sitting on my private jet about to fly off. Well, really what they did is they paid like $100 to get 5 minutes in the plane to take the picture. And there's a whole line of other influencers that are waiting to sit there. And then they flew coach somewhere else. Okay. So they may not have the wealth. And most people that do these just blatant violations don't. But, if you want to send me her information and, I'd look her up on the New York Secretary of State, see if she's a real business. Probably there's nothing to do. Okay. But if there is, then yeah, those can be, pretty big violations. Let's see. Murley, dispute a lot of reporting errors on one of my charge-off accounts, asking TransUnion if all information is not both complete and accurate must be deleted. Got an alert that it's closed. What should I be checking for when I get the new report? Yeah, I would just check to see, start with those errors that you identified. Have those been corrected? Okay. Is the account still on your report? If it is, have those errors been corrected? Are there new errors? If there are new errors, you might need to dispute again. But if they kept the account and they did not fix the errors, then I think you need to look at suing. Let's see, Jonathan, Greek course was great. Never received spreadsheet sample letters. Okay, yeah, I'll get that. We had mediation all day yesterday, and then kind of from the moment I got up this morning till right before I jumped on this webinar, it's been pretty nonstop. So if you send me an email, I'll reply back to you and get you all that. Let's see. John said she sent me copies of letters. She claims she sent the bureaus, but never seen any of the accounts in dispute in 10 months. Yeah, I would just say, well, how'd you send them? Send them U.S., first class mail? Did you send them certified mail? And I look, there are some legitimate credit repair folks. You've got to vet whoever you're using, and I would make sure that they actually give you proof of what they're doing. Okay, so if you now let me just say this: it costs money to send a certified mail, and you can't go to the cheapest person and then expect them to do certified mail because they're not going to make any money. So if they're not doing certified mail, you know that. Okay, I know that. But if you're paying for it and you say, I want you to send these certified mail, and they say, yes, they'll do it, then make sure they do it. You should get the tracking number. You can watch that, that letter all the way through till it gets delivered. So that's a good way to do it. And let's see. Okay. All right. John said she did not send certified mail. Yeah. So, unfortunately, if it's not sent certified mail, it's just really hard to prove. Okay. And there's something called the mailbox rule each state has. I'm not saying it's impossible. I'm just saying you fight, in my view, an unnecessary battle when you don't send this by certified mail because Equifax says we didn't get it. Well, you could go all the way to trial, spend a ton of money, a ton of time, get all the way to trial, and the jury goes, wow, they should have fixed that blatant errors, but I don't think that you actually sent it. Or I believe you sent it, but I believe Equifax didn't get it. And I'll just tell you this, we have reports, whether they're true or not, I guess the companies know and God knows, right? But we have reports of credit bureaus just saying, hey, we got 4,000 letters, we're behind, just throw them all away. Okay? I know mortgage companies did that in, sort of the Great Recession. There's one report, I don't know if this is true, sort of an extreme example, but they would just throw the FedEx packages. So when you're doing a loan modification, they'll send you a FedEx. You send that back to them. And they had so many in a room that the report is anyway, the room collapsed because they had, like a year's worth of, they just throw them in there. And then when you say, hey, did you get my loan modification paperwork? They go, no. They're like, I sent it FedEx. Yeah, we didn't get it. You signed for it. Oh, well, it's been somebody, So just understand, even sending certified mail, I'm going to say the most we get is on average 60% of the companies will, do something with it. So what I mean by that is if let's say that I had 5 disputes to Equifax, like 3 of them they would respond to, and 2, in my experience, they would not. Okay, so this is when it's sent certified. They had to sign for it. They know that we spent money to prove they got it, and they still ignore it. So what do you think they do with regular mail? I mean, I know some people still do it. Some people apparently have success with regular mail, but it's not something I would recommend. This is also my business model. We do typically one dispute. It doesn't get fixed, we sue. So we're not doing round after round after round. And so, it's definitely worth it to me. All right, let's see. This will be the last one here from Ryan. In the dispute I did for my client, there were months of missing information from TransUnion payment history. Dispute pointed out the missing information. They responded by deleting all the information in the payment history, except where the account was current or late. They made the report even less complete. Yeah, it's an interesting thing, Ryan. I have started seeing that with TransUnion, that they might have, 2016, 17, 18, 19, and they only have part of it, and they'll just delete a lot of it. So the question, and this is more of a legal question, does that make it incomplete? To me, it's an easier argument when they have the fields available and there's just no data there. Okay. But what if they just don't report it at all? Well, then let me say it this way. They have a better argument. I still think they lose, but they have a better argument if they deleted a bunch of negative months. But what if they deleted months where we were current and they deleted that? Well, now I think they have a much weaker argument. We have a much stronger argument that is incomplete and it paints a misleading picture. I've seen some credit reports that only start with 30 days late. Like, really? Like that's all you're starting with? Or one I think was 120 days late. That was the first reported month. I think that's a little bit incomplete. Okay. So I'd be curious about your thoughts on that, Ryan. And, um, just get with me on that. And Robert said, you want me to call you or email? Just email me, Robert. That'll be fine. And I'll take a look at all those. And listen, you guys have a great rest of your week, fabulous weekend. And send in some, discharged accounts if you have those. And we'll put some of those up on the screen and just go through them. We'll learn together next Thursday at 1 o'clock Central. Okay, guys, have a good one. Bye-bye.